government property. The state may, by notification, designate an officer above the rank of a collector who shall conduct an inquiry as per law and determine whether such property is a government property or not, and submit his report to the state government. So he has to make a determination. What is the determination that he makes? That this is government property. Obvious, Mullah, from the plain language. So he has to first determine that it is government property. Then it says, provided that no such property shall be treated as Waqf property till the designated officer submits his report. So two propositions arise from there. Proposition number one, before he determines anything, before he inquires into anything, it shall not deem to be a Waqf. Under what principle of law can that be substantiated and upheld? Which principle of law? Before you start an inquiry, on the basis of any question that may arise, the question will arise in your mind, or somebody files an application. And the moment that question arises, till such time as he submits a report, what report? That it is government property. Determine. It's not a Waqf. So under which principle of law can this be sustained? Not his counter affidavit, nor his written submissions, nor his saying title remains with me, possession remains with me, I cannot be evicted. Where did he get from the statute? It's not there in the statute. You have to read the statute. There are judgments of this court say, read the language of the statute and interpret the language. So point number one, the declaration that it's deemed to be treated as Waqf property till he submits his report without any basis, because there is a question that has arisen, is per se unconstitutional. Per se unconstitutional. And he has not answered that. And there is no time limit as to when he is to submit his report. So it will be treated as not as Waqf property, no time limit, no inquiry, it's before inquiry. That's point number one. Point number two.
That means it is after the inquiry starts.
Yes.
But prior to the report.
Yes. So he may take 6 months, he may take 1 year. So I have lost my right, as the community has lost its right as a Waqf. If you don't, will you allow me, sir? I did not interrupt you for a minute. I request my learned friend not to do so. But that's, you sighed, let me say. And rightly so. So, that's the point. Point number two. What does he have to determine? That this is government property. As your lordship knows, the revenue entry will only be changed once you have determined your title. Can't be changed just like that. I am in possession. Take a normal suit. I am in possession. In that property, revenue entry is in somebody else's name. He'll have to file a suit. That, look, I'm in wrongful possession. This property belongs to me. The revenue entry is mine. I don't have to go to court. He has to go to court. So, therefore, the determination that is government property is determined by him. None of this is pay me. It's behind my back. There is no procedure. So the point number two, there is no procedure established here as to how this determination is going to take place. Which law is going to be followed? Which is that procedure? Ex facie arbitrary. No procedure prescribed. He says inquiry as per law. What's the law? 83. So he has to go to court. Then why the designated officer? There is no other law. In this statute, Maharaj, other than 83, there is no other law. So as per law, if you interpret it to 83, he has to go to court before that determination. And other than that, there is no other procedure. Kindly see, it's very interesting. 83 says, if any aggrieved party, subsection 2, any mutawalli person interested in a waqf or any other person aggrieved by an order made under this act or rules, any other person aggrieved by an order made under this act or the rules may make an application within the time specified, and where so no such time is specified, within such time as may be prescribed. This is the only mode. This is the only mode. There is no other law. And the expression law in subsection 2 is as vague as it can be, because we don't know what that law is. Now the counter affidavit says, no, sir, but you will be heard. Very good. So now the counter affidavit will decide what that procedure will be. The statute will not. How does the title remain with me, Manoj? As he said, he's already determined. That's after he gives the report. I'm not. Before that, I've already made my submission. He's already determined. This is government property. Then only will the revenue entry be changed, Manoj, because it's sequential. After determination, in case the designated officer determines the property to be government property, he shall make necessary corrections. So the corrections can't be made till he determines it's government property. Therefore, Manoj, it's not just a revenue record change, which is the basis of his argument under 3C. Then how does he say? It's just a change of revenue records. And what's the explanation for this, Manoj? None. And it's irreversible, Manoj. Irreversible. The right of the community is taken away merely because there is a question that arises. Right, Manoj? And this particular section relates only to government property. I made these submissions, Manoj, earlier, not answered. Answered by the counter affidavit, but I say the title will remain his, possession will be his, he can't be evicted. Why? Who says that? Now, let's kindly see the definition of, in 3R, the proviso, which we've been reading. So now I've dealt with government property. Let's be dealing with something else, which is much worse. No, not use it. No, I'm just saying something else. Kindly see. See, the Waqif means any person making such dedication.
So
the 3R proviso. May I read it? My lords, much as my share. Provided that the existing waqf by user properties, registered on or before the commencement of this Act of 2025 as waqf by user, will remain as waqf properties, except that the property wholly or in part is in dispute or is a government property. So if you take the government property, waqf as user, that 3C will apply. And the same
would apply.
It's government property.
While determination.
Sorry?
If the collector initiates process for determination.
Yes.
Then only 3R would.
Yes, so it says now, except property wholly or in part in dispute or is a government property.
Somebody will have to claim that it is a government property.
That's correct. Who will claim? Not I.
The government.
Yes. And how will he claim? By going to the tribunal. because I am occupying it. I take example, one simple thing. Well, I am very simple. I have a burial ground. It's remained there for 200 years. There are so many burial grounds in this country who were there for 200 years. Now, we don't know how it happened to be that, but burial is an essential part, is integral to the Islam, right? After 200 years, the government says, no, this is my property. Can burial grounds be taken over for?
No, but if you have registered, if you scheme the act from 1923, on 1923, though technically you may be right that there was no provision for registration technically, but the information was given, required to be given to the authority.
Well,
and then from 19...
Information to the court.
Whether we don't compete with that young...
Yes and no, I'll
Then
absolutely right.
Continuously from 1954,
I will.
The registration is required, and that 1976 report also.
Yes.
We can read that report as to why registration was found to be.
I am at one.
It is not as if that from 1923 till 2025, over a period of 100 and odd years, if the scheme of various enactment has emphasized on a registration, and if somebody has not registered,
Correct. I must answer that. No? I'm going to answer it, and I have a full answer for it.
because we believe in having an open dialogue.
Correct. I have a full answer because I knew that that question will come from your lordship. But at the moment I'm reading the section, I'll answer that immediately. I'm reading the section at the moment. It may not be 100 years old, it may be 3 years old.
3 years old, if it is registered, it will be protected.
But it may not be registered. Waqf by user may not be registered. I'm coming, there's a judgment of the Supreme Court, any number of judgments, it need not be registered. That's settled law by the Supreme Court. Settled law. So I'll come to that later, but I know what is in your lordship's mind. That's why I'm not wasting too much time, just going straight to the point. Because I don't want to just dilly-dally.
We must tell you what is in our mind so
Correct.
that we can get the answer.
Absolutely. Now, therefore, let's leave that out for a moment. Waqf by user of government property. Come to this, or in part is in dispute. It's a private person. If it is in dispute, Malaj, then how is it not waqf? Government property is 3C. But is dispute...
There is no such procedure for any property with regard to private property, like 3C.
Yes.
So it's only 83 where the people, if somebody is disputing.
Yes. What will happen is, here the survey is not there now. I'm just giving your lordships an example. There's a private dispute, waqf. Under the law, it's no longer a waqf. But just by this expression is in dispute. At least, Malad, in 3C, there's a determination that it is government property. There is no such determination here. There is no procedure of determination. There is no reference as to how this dispute is going to be determined. There is a declaration by law, by the legislature, that if there is any dispute, it shall not be waqf at all between two private parties. Under which law can this be sustained? Can't be.
Yes.
Now, your lordship, very important question. You also said, what is waqf by user? I give you a note because I'm going to answer that question. But your lordship has it?
Yeah, can we?
Yes.
Tables up, can we?
Yeah, we just give it. No. One second. Now, just briefly, orally, I'll tell your lordships. In the 1954 Act, for the first time, they said these mutawallis are not the kind of persons who should be handling all this because they won't register. In the 23 Act. And then ultimately, it was decided that there should be a survey. And for the first time, that was decided in 1954. That we now must survey these properties to find out what is Waqf and what is not. 54. Then came 1995. And in 1995, there was a whole procedure. Nothing had been done. That's not Mutawalli. It's the states who were to survey, not the Mutawalli.
That's what Mr. Rauf also said, that his petition is pending from 19. That
No, but I'll show
even
more egregious, because I'll give you data now. There are only 2 Waqfs registered in Delhi.
serious.
There is 0 Waqf registered in Jammu Kashmir. But anyway, that's their data, not mine. But I just point that out as to why this happened. Why this has happened, I'm pointing out. In 1995, there was an elaborated procedure. That, no, we must go and we must do it very quickly. Nothing done. No state government acted. Then in 2013, they said, okay, you guys have not acted since 1954. Now these surveys must be over in 1 year. I'm answering the question why they were not registered. The argument is they were not registered, so they lose their character as Waqf. I am telling your lordships why they were not registered. The failure of the state government to not do their job. From 1954 to 2025. And that failure, with that failure of the state government, the community is going to be punished because it was not registered. That's the argument. Now just read the note with me, Malat. It'll all be clear. Malat, kindly come to Roman 2. That's page 2 of the note. Justify the ouster of unregistered Waqf by user from the protection of the Act. I'm sorry, Justice Messi has it. Yes. The page 2, Malat, on the left-hand side, Roman 2. To justify the ouster of unregistered Waqf by user from the protection of the Act, the Union contends that there has been a consistently mandated legislative intent of registration for all Waqf, including Waqf by user, since 1923. Exactly what my Lord said to me. And that affording protection to unregistered Waqf by user puts a premium on those who have been defying the law of the land since more than 100 years. This contention must be rejected. The statutory consequence of non-registration of Waqfs under the Acts of 23, 54, 95, 2013 have never taken away the title of the Waqf. Mandatory nature of the requirement to furnish details or register the Waqf was limited to penalties being visited. This argument we've already made. Well, let's forget this argument for a while. Now come on. Statements of objects and reasons of the Mussalman Waqf Act 23 shows that the requirement of disclosure of Waqf properties to the court was introduced because, in some cases, difficulties have arisen in finding out whether any particular properties are really subject to Waqf or not. There are numerous Waqf properties all over the country, unknown to the public, which the Muttawallis are treating their own private property and dealing with in any way they think fit or necessary. Therefore, it is clear that the evil that the 23 Act sought to remedy was that of unscrupulous Muttawallis evading public disclosure to escape accountability. This system was still dependent on the Muttawallis voluntarily registering the Waqfs. And therefore, the Waqf Act of 54 introduced, now this is the important thing, Section 4 and 5, which required the state to conduct a survey and register Waqf properties, thereby placing the onus on state governments to identify Waqf properties. This was continued in the Waqf Act of 1995. In addition, Waqf boards were given the power under Section 40 to identify Waqf properties which escaped survey, which has been abolished now. Section 40 goes. Now it's with the collector. Survey has been abolished. Well, just look at the egregious nature of this legislation. Despite this, it was noted in the statements of objects and reasons of the Waqf Act of 2013 There is no time limit fixed in the Act for completion of such surveys. So far, only one state has completed the survey. Well, this is the most important factual statement. In other words, from 1954 to 2013, only one state had completed the survey. Whose fault is it? Muttawalli's. This is your legislation. And Malaz, how does a person who is enjoying the benefit of the work find out whether it's Waqf property? What is this going on? So the community will be deprived because the surveys are not done by the state government. And now you will say because it's not registered, it's not a Waqf. This is, it's per se expropriatory.
Your responsibility is to register goals.
Back to my submissions. Kindly take Malaz volume 1 of the preliminary counter affidavit that the state government has filed. Just volume 1. Yeah, I'll come to that. I'll show that. Correct.
Yes, page.
Page Malaz 158. There's a chart, Malaz, your lordships have to turn it around. It says annexure R1.
158.
Yes, 158. Lordship has the chart? Yes. Just an idea, Malaz. In state, for example, Telangana. We know, Malaz, Telangana very well, Malaz, as to how much how many members of the community live there. Number of properties registered in 2013, zero.
For registration.
Zero.
So nobody went for registration.
If you don't mind, again, will you? I don't know why you are interfering. Why should you? You should not say all this. Worried.
Yeah.
So, Malaz, therefore, zero. Who has not registered them? The survey commissioners. Not done their job. And now the 2025 Act says, we didn't do our job, so you've lost your right. That's the law. Is that reasonable? Isn't it per se unconstitutional? No, there are many such instances. Take, for example, Jammu Kashmir 1. Take Delhi Waqf Board 9. Percentage increase 1,153. Obviously, there will be, because you haven't done your job. Third from the bottom, Shia Central Waqf Board, 0. In Uttar Pradesh, 0, Malaz. Imbabara, famous Imbabara, will go. Doesn't exist now. Malaz, just see the serious consequences of all this. And all this, my counter affidavit says
I
this.
must come in here, my lord. There
Please,
is,
please,
my learned friend is saying something fresh.
It's your
Give me
affidavit.
1 minute. Give me 1 minute.
No, I'm
so that
sorry.
we may be
I'm
not
sorry. I'm sorry.
taken
I'm
for
sorry.
a ride,
I'm
not
not-
unnecessary.
He isn't rejoined.
Yes, sir.
This is on Vamsi portal.
I'm coming.
Most of the boards
If you-
have not
I'm
updated
sorry.
figures in Vamsi portal.
Why are you interrupting him?
Please allow me to answer.
We did not permit them to.
I did not allow me, Wallace. Allow me. It's not fair. It's not fair at all. You make all kinds of statements and you say, we have misled the court. Every time, Wallace, every other half an hour, you would say, I'm sorry to say they misled the court.
But then there are also states where.
No, kindly see the second column.
Look, Mehta, please, please control yourself. We are telling you time and again that don't try to compete with that young girl assisting Mr. Sibal and disturbing him.
I'm not saying no, but Wallace, the question is, and see the last report.
No, but you see, there are states wherein, like
Therefore, there may be many more. Wallace, I'm pointing.
Tamil Nadu is Tamil Nadu, Punjab,
Maharashtra, 50,000.
Maharashtra,
Yeah, but there may be many more.
Kerala.
Wallace, works are all over the state, all over the country. And those may be voluntary registrations. Because only one state had done. Kindly see the latest Vamsi report at page 63 of the rejoinder affidavit, or my rejoinder, 276 of 2025. I mean, this is shocking. And this is also 2013, Manoj, as of 2013. Sorry, I'm sorry. It is a rejoinder affidavit 276 of 2025 lead matter, page 63. Because I need to finish because others have to speak. Therefore,
So therefore we are not interrupting you much.
and you are not, Manoj. I'm just saying. I'm trying to be fast and not going to all the other issues.
Because we have to conclude.
You have been very kind, Manoj. Yes.
I think there has been least interruption from.
That's true. That is true.
Unless it was.
Well, we cannot blame you for that, Manoj.
Unless it was really necessary. And then on this chart, they have themselves made submission at page 7 of the counter. They have themselves made this submission, saying that, look, our people did not work. We'll come back? Okay. We'll come back now. Yes, we can proceed and ask someone to find it out. So,
Okay, Manas. All right. While they find it. Now, Manas, kindly see.
we have to conclude.
Yes, before we'll conclude, Manas. No issue at all. Because now, Manas, kindly read one judgment of Justice Fazal Ali. Give me that judgment.
2 hours in the Jordan?
It's here.
What side we curtailed me not 2 hours in the Jordan?
Kindly. Now, this is 1976 4 SCC, page 780.
1976.
1976 4 SCC 780, para 36 and 39. Yes. Now, kindly see. Yes, 36 and 39.
480, 36 and 39. निकाल है फोन में मैं भी इसमें निकालता हूँ
At page 803, starts at 780 at 803, para 36.
जीरो नहीं हो सकता पेज
Page. 603.
Yes. Amir
Ali, in his book, Mohammedan Law, has given several instances of a complete and irrevocable dedication made by the Waqf for the founder and the consequences flowing from the same. Amir Ali observed as follows: the proprietary right of the Waqf is a building or ground set apart for prayers becomes extinguished